Welcome to our webinar hosted by LCF Law in conjunction with Leeds Digital Festival. My name is James Sarjantson. I'm a commercial and digital solicitor and partner at LCF Law. Also presenting with me today is my colleague Thomas Taylor, who's a commercial and digital solicitor also at LCF Law. So today we're going to talk about the new Digital Markets Competition and Consumers Act 2024. So who is this relevant to? Well, this is relevant to businesses who sell to consumers. So if you're a business that sells to other businesses, this isn't relevant to you. If you sell to consumers, it is. Of course, if you're on a website and you're selling to both businesses and consumers, then of course it's going to be relevant to you because you are selling to consumers as well as other businesses. Now, the act that we're going to talk about, as you can see from its title, is partially in force. So it partially came into force in 2024, but the consumer protection elements of it that we're going to talk about in this webinar, they are actually not yet in force. They will come into force probably end of this year, early next year is the best timescale that we've got at the moment. So there is time to understand it, to get under the skin of it, and to ensure compliance. So this is a bit of a horizon scanning as to what is coming. So hopefully you can take action before the act actually comes in. So if there's one thing that I want people to take away from this webinar, the key thing that I want people to take away from this webinar is that going forwards, breaches of consumer protection legislation are significantly more likely to result in a fine than used to be the case. And that is because this new act gives the Competition and Markets Authority direct authority to A, determine whether consumer protection legislation has been breached, and B, to issue direct fines to infringers. Now, this is significant, and it's quite a departure from the previous situation, because of course previously the public bodies enforcing consumer protection legislation, so the CMA, trading standards, etc., if they wanted to issue a fine to an infringer, they would have to essentially take them to court. And so just like for the rest of us, litigation for them is both expensive, can take a long time, and the outcome is essentially uncertain. And they've only got finite resources like the rest of us. So the net effect of that was that in reality, your chances of being fined for breaching consumer protection legislation are actually relatively, statistically relatively limited. This new act is clearly putting that all on it completely on its head by giving the CMA direct authority to A, determine that whether you're infringing or not, and B, to issue a fine. Now, whilst those other authorities, such as local trading standards, they can still take people to court, it's just the CMA that have got the powers to, the direct fining powers. And those powers are significant. So as you can see from the slide, that they can fine up to £300,000 or 10% of the infringing company's turnover. So if you're turning over £500,000, you could be fined up to £300,000. If you're turning over 10 million, you could be fined up to 1 million. So we're talking really significant fines here. They also have quite wide powers in terms of group companies, believe it or not. So if a fine is issued against a particular company, and then that's part of a group, and that group is reorganized to make the infringing company dormant and move the trade into another company, they can actually drop that fine over into a different group company if there's been a restructuring with a view to trying to avoid the fine. So they've got pretty wide powers. It's also worth mentioning that a lot of consumer protection legislation, if it's breached, it's actually a criminal offence. That's not really new. That's been the case for some time. And in the most serious cases, you could actually be talking about imprisonment of up to 2 years. But the reality is, again, that was only for the most egregious, the worst type of infringements. The reality is a fine is much more likely, but that is the likelihood of you actually getting a fine now going forwards is going to be much greater. Again, it's also worth mentioning that directors of companies themselves can also potentially be liable for fines on an application to court. And again, this isn't necessarily new. But you've got to be aware that as a director of a business selling to consumers, if your company breaches the legislation and you're actively part of that, you're part of the management, you're aware of that, then you could actually be fined personally on an application to court. And again, that's not necessarily new, but it's important to be aware of it. So if you do get investigated by the CMA, it's important to actually engage with them. Your conduct during an investigation can either increase or decrease the fine that you get. So if you're cooperative, if you engage with them, and if you provide them with the information they ask for when they ask for it, that will decrease the fine decrease any fine that you ultimately get because of your conduct during the investigation. Equally, if you don't do that, then the fine will probably go up. There is scope for the CMA to enter into undertakings with infringers, which is basically a kind of non-admission of guilt undertaking, which may well avoid a fine. Clearly, the CMA will only do that if they think they can dispose of the issue quickly and competently by engaging in undertakings. And if you sign up to undertakings with the CMA and you subsequently breach them, then clearly you are absolutely in line for a heavy fine from them. But it is a possibility, and it is a route that a lot of companies will go down. They will probably negotiate with the CMA and enter into undertakings as to their future conduct going forwards. This isn't necessarily a complete get out of jail card. It may result in not getting a fine direct from the CMA, but there may still be a requirement as part of those undertakings to reimburse any customers, any consumers who the CMA think has lost out as a result of your actions. So it's not necessarily free of financial risk, but it's certainly better than getting a fine. So what are the CMA actually going to be enforcing? Well, the consumer protection provisions in this new act, a lot of it actually isn't new. A lot of it's actually been around for, say, 15 years or so, but it's not necessarily that well known. I mean, there are some new provisions. In particular, there's new provisions around fake reviews, which I'll talk about later. There's new provisions regulating subscription contracts, which Tom will talk about. But a lot of it isn't necessarily new, but equally isn't necessarily that well known certainly amongst businesses that we engage with. So it's worth talking about the key things that the CMA are going to actually be enforcing. And one of the key things is the general prohibition on what's known as unfair commercial practices. So what that is a ban on misleading actions, misleading omissions, and aggressive practices, which, as a result of those actions, could deceive consumers essentially into buying something that they wouldn't otherwise have bought. So what does that mean? Well, a misleading action might be, for instance, crossing out an old higher price and putting a new price to indicate a discount, when in fact that higher price that you crossed out, you'd never actually charge that at all. Clearly, that would be misleading consumers into thinking that they're getting a discount, when in fact the trader never actually charged that higher price at all. A misleading omission might be in an ongoing contract, perhaps an ongoing contract for services with a consumer. If they try and cancel that contract and there are heavy penalties, heavy penalty costs for doing so, which you didn't make clear to the consumer when they entered into the contract, that would clearly be a misleading omission. You didn't tell them about some penalty fees that would be payable if they walked away from the contract. That's not to say that you can't put penalty fees in place, but you can't put those fees in place and not tell the consumer when they enter into the contract. They need to be aware of it. So an aggressive practice, that might be, so a good example would be, you take your car into the garage to fix the radiator. While it's there, they put in a new exhaust system. When you come to get it, they require payment of both the radiator and the exhaust system, which you didn't ask for and they didn't tell you about, and they won't give you the car back unless you pay for all of it. That would clearly be aggressive action. That would clearly be unlawful. There's also a kind of general catch-all, which is known as a breach of professional diligence, which is essentially is basically any other dishonest practice between consumers and between businesses and consumers, which as a result of which those consumers might take an action, might buy something that they wouldn't otherwise have done. It's just a sort of catch-all. So who is this targeted at? Well, it's designed to protect the average and reasonably well-informed consumer. So it's not designed to protect what's known as the idiot in a hurry. Those kind of people will always be confused and will always be potentially deceived by stuff that isn't necessarily dishonest. So the standard is basically, well, what would the average reasonably well-informed consumer think about what you've done? Would they be deceived? There is an exception to that, which is if you're actually actively targeting vulnerable groups. So if you're actively targeting the old, the infirm, then the standard is essentially, well, what would the average old person think about it? So you can't defend actions on the basis that, well, this old person was confused, was deceived, but most normal people wouldn't be confused by that. Well, if you specifically target your products and market your product to the elderly and the infirm, then the standard is, well, the average elderly infirm person. There's a second set of unlawful practices, of which there's about 20 odd listed in the Act, which are generally regarded as so unfair that they are banned outright. So there's no need for the CMA to show that those practices would result in a consumer being deceived or could result in a consumer being deceived. These practices are regarded as unhelpful, unfair in any event, and they're simply banned outright. So there's a list of 20 odd. A couple of examples are fake reviews. Move my slides on here. Fake reviews. So I'm going to touch on that later. Fake closing down sales. So if you're flashing on your website, closing down, here today, gone tomorrow, buy it now, when simply that's not the case and you're going to be continuing trading tomorrow, then clearly that's deceptive. Clearly you're misleading customers into buying stuff. False representations about legal rights. So if you're saying to a consumer, buy our product, if it doesn't work, we'll give you your money back, you can't get this anywhere else. Well, clearly that's untrue. If you sell to consumers and the product breaks, then it breaks, it isn't fit for purpose, then they're entitled to a refund anyway. So saying that you can't get that anywhere is simply wrong. That's a right that consumers have. Falsely stating that your product is only available for a very limited period of time, in order to try and pressurize customers into buying now. That's banned. These are often known as urgency claims. So, for example, telling a consumer that the prices for a product will go up in 24 hours time, often accompanied by flashing timers and countdown timers, etc. If that's not true, if that's simply not true, then that clearly is a banned practice. That's clearly deceptive and unlawful. Equally, telling customers that special offers might end on a specific day when that's not true. Deal ends tonight, when that's not the case, that's banned. Misleading claims about stock levels. So again, flashing messages, selling fast, only 5 left. Well, if that's simply not true, or it's just going to get restocked tomorrow like normal, again, you sort of putting that urgency on customers to buy products that they might not otherwise have bought. These kind of actions, these kind of urgency claims, particularly on websites, are known as dark patterns. So dark patterns is the way that website digital infrastructure and default settings can kind of manipulate consumers into buying products that they might not otherwise have done. And this is important because this is a really big focus for the Competition and Markets Authority at the moment. Dark patterns and also environmental claims, dubious environmental claims. These two things are big focuses for the CMA at the moment. And just as an example of that, there was some enforcement action that the CMA took against a company called Wowcher. which is a deal of the day type website, which happened recently. So Wowcher did a lot of these kind of urgency claims, lots of countdown timers, running out in high demand, a lot of these things flashing up on the site, when apparently that wasn't really the case. So the CMA investigates it, and the outcome of that was that Wowcher entered into undertakings as to their future conduct. But as part of those undertakings, they had to refund their customers, to the tune of over £4 million. So that's a significant amount of money out of Wowcher's back pocket that they had to pay to reimburse consumers, as part of this settlement with the CMA. And I think with these CMA powers, we're just going to see more of this going forwards. So there are we're only trying to sort of scratch the surface really in this short webinar. There are some new provisions in the new act about information that needs to be provided to consumers when you're marketing to them. But a lot of that is fairly self-evident. In my view, most traders would be compliant with that kind of stuff anyway. So I'm not going to extend this seminar by just going through things that you're probably compliant with anyway. We're just going to focus on the key things. And one of those key things is the new changes to subscription contracts and how they're regulated. So I'm going to hand over to my colleague Tom, who's going to tell you a bit more about that.
Thanks, James, and good morning, everybody. So as James says, I'm going to talk about subscription contracts and the new legislation and how that affects that. Before I do that, though, I just want to have a quick overview of existing consumer protection legislation, and specifically consumers' rights to cancel. And that's because the new rules in relation to subscription contracts will build on this existing legislation. So when it comes to the sale of goods, services, or digital content online, then consumers have a right to cancel their contracts with you within the cancellation period, and they don't have to give you a reason for that cancellation. Now, just to reiterate, this only applies to your contracts with consumers online. If you contract with a business, then the business does not have these cancellation rights. So as you can see from the slide, what are the rules here? Well, if you're selling goods to consumers, the consumer has 14 days from the day that they take possession of the goods in order to cancel the contract and return the goods to you. If you're selling services online, the consumer has 14 days from the day that the contract is entered into to cancel those services. And if you're selling digital content, and by digital content, we really mean downloads of software, music, video games, etc. If you're selling those, then just like with services, consumers have 14 days in which to cancel the contract from the day that they've entered into that contract with you. However, if they've already downloaded the digital content, then they can't then cancel it. Next slide, please. Now, please be aware there are certain circumstances where a consumer does not have a right to cancel their contracts with you. The examples on this slide are not exhaustive. There are more than this, but I've just picked out some of the key circumstances. So relatively low value contracts of £42 or less, they don't have a right to cancel. If you're selling customized, bespoke, or personalized goods, so for example, if you're selling a necklace that says, "I love Dave," then the consumer can't cancel those types of contracts. And that's just purely on the basis that it's harder for you to resell something that's been personalized for somebody else. If you're selling goods that are sealed and then become unsealed and they're not suitable for return due to health or hygiene reasons, these contracts can't be cancelled. So a classic example of that would be if you're selling a sealed packet of underwear online, something like that. And the final one I'd point out is just goods which may expire or deteriorate rapidly. So if you're selling food online, the consumer can't return that food to you unless there happens to be something wrong with the food. So where a consumer exercises their right to cancel, you must reimburse all payments received from the consumer, including delivery costs. However, just please note that while you are obliged to refund delivery costs, you're only obliged to refund standard delivery costs. if a consumer elects to pay extra for express delivery, for example, you would only have to refund them the value of your standard delivery. You wouldn't have to refund them the difference between the standard delivery and the express delivery. Also, if you send goods to a consumer and then they send it back to you damaged, the consumer will be liable for the devalue of those goods because they've been damaged. So when must it be refunded? Well, without undue delay, but in any case, generally within 14 days of the receipt of the goods or cancellation of the services. Okay, so that was the existing position in terms of right to cancel. I'm now going to just look at subscription contracts because there are new rules in relation to those. Now, for the purposes of the Act, a subscription contract could be either a contract for an indefinite or fixed term period where the consumer makes recurring payments that they can terminate at any time, or it could be a fixed term contract that they can terminate early. So your typical Netflix or Spotify subscription would be an example of an indefinite term contract. However, or alternatively, if you offer your consumer an initial free or cheaper period that then turns into a full price contract and the consumer has the right to cancel that contract at the point that it becomes full price, then that would also be counted as a subscription contract under the Act. Next slide, please. Okay, so in addition to the standard 14-day cooling off period that we've just gone through, consumers under a subscription contract will get a further 14-day cooling off period, both on the expiry of any initial free or discounted period, or if it's an annual contract, every time that that contract renews for periods of 12 months or more. And I should just state that the rules that we said about consumer protection legislation, while I said that only applies to contracts that are entered into online, these rules around subscription contracts could apply regardless of whether you enter into that subscription contract online or not. Next slide, please. Okay, so aside from those cancellation rights, when you enter into a subscription contract, you now have to give certain pre-contract information. So you need to advise your consumers, well, if they enter into an initial or reduced fee period, you need to advise them that they will be charged at the point that it becomes a higher charge rate unless they cancel the contract. For all other types of subscription contracts, you must inform the consumers that the contract will continue either indefinitely or for a fixed term unless they take steps to cancel it themselves. You must advise consumers of the frequency with which they will become liable for their subscription payments and the minimum amount that they will be liable for on each occasion. And if it's not a monthly subscription that you're offering, you must still inform your consumers of the amount that they would be liable for each month if it was a monthly subscription. You must also tell consumers the minimum amount that they will be liable for. You must tell them what they need to do to cancel the contract and the amount of notice that they need to give you. And finally, you need to send them auto-renewal reminders to remind them of their cancellation rights. More of that on the next slide. So next slide, please. So you now must notify them of all upcoming renewal payments. The new legislation doesn't say what form that reminder needs to take, but you must tell them. So when there is an initial or reduced fee period, you need to send them a reminder before the end of that initial or reduced fee period. If you have a subscription which renews for less than every 6 months, so for example, a monthly or a weekly subscription, then you need to send a reminder in respect of the last payment due before the end of every 6 months. And if the contract renews on something that is less frequent than every 6 months, so let's say an annual subscription, then you need to send them a reminder for every renewal payment. Next slide, please. And just on a final point around subscription contracts, so there are a few special requirements as well. So when a consumer enters into a contract with you, they must expressly acknowledge that they are aware that the contract imposes on them an obligation to pay. And if you don't require your consumers to acknowledge this, the contract wouldn't be binding, and therefore, obviously, there's no obligation for them to pay you. The next point would be that you must advise all of your consumers in writing that if there are any restrictions on delivery and what methods of payment there are. And finally, all of this key and full information must be presented in writing, and you must present it in a way where they don't have to take any additional steps to access that information. So if they have to click on a link to access this information, or if they have to download something, then that's going to be a problem for you. That will be a breach of the new legislation. Next slide, please. Okay, and finally, I just want to touch on something separate to subscription contracts, which is drip pricing and new legislation around drip pricing. So, well, what is drip pricing? Drip pricing is a practice where companies only advertise part of a product upfront, and then they reveal extra changes additionally later on in the buying process. So, for example, if you've ever purchased a flight on Ryanair, then you've experienced drip pricing. So just as a general rule, drip pricing is still acceptable if, as in the case of Ryanair, you're paying for additional services that you may want that you don't necessarily need. So in the case of Ryanair, that could be additional baggage or the right to book your seat, priority boarding, that kind of stuff. You may want those things, but you don't necessarily need them to get from A to B. However, drip pricing is a problem when a consumer's drawn to an additional low price and then there are mandatory costs that are added on at a later date, which means that the price is misleading. So what the new legislation says is that any advert which shows a price must show the total price, including all non-optional costs like delivery and booking fees. And if you can't calculate those in advance, you need to give information in the advert as to how that may be calculated. And the advert must also include any applicable charges and taxes, like freight and delivery charges. And if you're not able to calculate that, you need to tell consumers that within your advert. That's all I have to say on drip pricing. So thank you very much, and I'll hand you back to James.
Great, thanks, Tom. So the last thing that I want to touch on in this webinar is around fake reviews. So this is one of the new things that's brought in by the Act. I mentioned earlier that the Act basically says there are certain actions that are banned outright. So the enforcement authorities, the CMA, don't actually have to show that they would deceive customers. They are regarded as bad in themselves and therefore banned outright. And fake reviews is one of them, and is one of the new ones. So what's actually banned? Well, submitting a fake consumer review is banned, as is commissioning another person to write a fake review. So if you get your brother-in-law who's never used your business to write a fake review, that is banned. Equally, publishing consumer reviews in a misleading way is banned. So if you publish a review that you've commissioned and paid for or incentivized, and you don't disclose the fact that it's been incentivized, you don't disclose the fact that it's been paid for or whatever, then that would be banned. Equally, if you've got a website that has an option for people to put reviews directly on the website, then you can't just delete the negative reviews and just accentuate the positive ones. If you are letting people review, then you've got to let people do that. You can't just let people review and then delete the negative reviews. And finally, publishing consumer reviews without taking reasonable steps to prevent the publication of fake reviews is banned. Now, this last one is actually the most important, really, because what this means is that traders are actually going to have to take some positive steps and implement new positive processes to essentially verify reviews before they're actually published. So inevitably, they'll only have to take such steps as are reasonable and proportionate to do that. But what is reasonable and proportionate in these circumstances is quite hard to say. The CMA have said that they are going to publish some guidance on this. And frankly, we await that guidance with bated breath, because it would be really interesting and informative and really essential to know what kind of steps the CMA expect people to take in this regard. But again, I flag it up now as something to really keep your eye on, because traders will have to take some positive steps to ensure, or to try and ensure, that fake reviews aren't published, and if they are, that they are removed as soon as possible. So one to keep your eye on, really. So that ends the formal presentation. It's been a real canter through it. It's just past 9:30. You know, there's so much really to talk about, but we just wanted to focus on the key things and really tell you what's coming and what to be prepared for. So you know, in conclusion, fake reviews is a new thing to look out for. If you've got a subscription, if you offer subscription contracts, there's new steps you're going to have to take. There's new documents and changes to your terms and conditions you're going to have to implement. Outside of that, all businesses really going to have to audit their processes, especially if they're using any urgency claims or dark patterns, especially if they're using environmental, pushing the green credentials, etc. Think about that pre-sale process. Think about that sale process, and if you need any assistance with it, then please let us know. We are here, and we are here to help, and our details are on the screen. So that winds up the formal presentation. Thank you very much for your time. Thank you for your attention. And if anyone's got any questions, then please drop them into the Q&A, and I'll take those questions now. So we had a question about businesses based outside the UK. Are they subject to the same rules? So the answer to that is yes. So if a business is targeting the UK, then they will be subject to the same rules, and essentially, even if they're based outside the UK. So essentially, if they are targeting UK and UK consumers, as you would hope, you know, they will be caught by this. And what's targeting UK consumers? Well, I guess if you're if you're putting prices up in pound sterling and you're accepting pound sterling, then that, I would say, is targeting UK consumers. So yes is the short answer to that. We had another question around, will subscriptions which have already increased from the introductory price be affected by these updates? Well, no, in that, Tom, you may know more about this than me, but the Act does not have retrospective effect. That is clear. The Act does not have retrospective effect. So in terms of previous subscription contracts where you've had an introductory period and you've gone up in price, it won't affect that, because it won't have retrospective effect. But clearly, if you're in that business, you are entering into subscription contracts all the time, you are going to have to put these processes in place for new subscription contracts. Frankly, you'll end up putting them in place for existing contracts as well. Got a question. How does the A/B testing of digital product conducted by an e-commerce company apply to the Consumer Protection Act, particularly that similar to that of dark? That's an interesting question. So how does the A/B testing of digital product conducted by an e-commerce company apply to the Consumer Protection Act, similar to that of a dark pattern? I'm not sure I quite understand that question, but to the extent that it's testing, it wouldn't really impact. I mean, ultimately, it only matters if it's you know, in a live environment. Dark patterns are intended to impact consumer behavior. So it's only if they are likely to impact consumer behavior, and it's only if they are genuinely misleading, that they're going to be relevant. They've got to be those two things, you know, misleading act, misleading emission, and likely to cause a consumer to change their buying actions, basically. And if that's not the case in the live environment, then it won't be caught by this. I hope I've answered that question. If not, please feel free to let me know if I've got the complete wrong end of the stick on that. I don't think we've got any other questions. Like I said, if I haven't answered that previous, got the right end of the stick of that previous question, then do let me know. Look, if there's no other questions, then we'll look to wind up. But you know, the details are on the screen. The details will be sent out to you. So again, if there's any queries, do feel free to get in touch with either Tom or I. We'll be more than happy to answer any questions. And the last thing is to say is just to watch this space as things develop and as the guidance comes out of the CMA. So thanks very much for your time. Thanks very much for listening, and hope you have a great rest of your day. Thanks very much.